Yes, Miss Farrington.
May it please your lordship, I appear on behalf of the appellant mother.
Yes.
And I'm leading Miss Story-Ray, who's
You are.
with me. And my instructing solicitor, Miss Carter, is here, as is the mother, Miss Howard. And at the back of the court is a pupil from my chambers who is here to assist. And then to my right is Mr. Sinclair.
Yes.
Who acts on behalf of the appellant father. And the father, Mr. Kerr, is also here. Further along the row is Miss Gibbon, who acts for the respondent local authority. And she is accompanied by the social worker, Karen Ward, and the team leader, Agnes Mugo. Then we have, along from that, we have Miss Jaffa, who represents Mr. O'Callaghan, who is the father of
the older child. The case being live streamed, so we must remember to not to use the name of the family names, or the children, in particular the children. Yes?
Thank you, Lordship. Yes.
And then you've got...
And then Miss Siepler is at the end of the row, and she is appearing on behalf of the children, R&T, on the instructions of their guardian.
Thank you. Well, I certainly haven't read all 1,200 pages of the bundle. We've read the judgment, the appendices, skeleton arguments, and in my case, and I think my colleagues too, we've looked at the reports of the principal expert witnesses in the case.
Thank you.
Can I just ask Miss Gibbon? We note your skeleton argument. Are you going to develop any arguments in support of your position, or are you content to leave to rest your case purely on the judgment?
I'm content to purely on the judgment.
Thank you.
My lord, there are two additional documents which I hope you have received, which is, one is that the skeleton argument had the page numbers, the PDF numbers.
Thank you very much.
Placed within it. And the second is a recent case which was only decided about a month ago.
Yes.
Which seems
this is the appeal from Judge... Never mind, the appeal from the court in Peterborough.
That's right.
I'm familiar with this judgment. I don't know if my colleagues are. We had it last night. You had it last... Did you see it last night?
I haven't read it.
Okay. All right. Yes.
So, my lord, the findings that we appeal against, and there is no criticism, I should say, of the work that went into this judgment in terms of it's clearly took hours for this learned judge to put together. It's the approach that we say is fundamentally flawed. And the findings that we seek to appeal are those that are set out, and we set them out, it's at 25 in the bundle, paragraph 2, which is PDF 32. My lord, if I go through those findings, that R suffered injuries as a result of acceleration-deceleration mechanisms, which could have been accidental or non-accidental in origin. This is more likely than not to be the explanation for the medical findings. It is more likely than not to be the sofa incident. A force more significant than the sofa incident was involved. The injury was sustained by R in the care of his parents, and he came to significant harm. The learned judge cannot identify a sole perpetrator. One or both of the parents would have or should have been aware of an event involving more significant force than the sofa. If accidental, it seems more likely than not there was a degree of recklessness or negligence. If unwitnessed, there was a degree of lack of supervision or awareness on the part of the adults involved. It was either deliberately inflicted, accidental, or negligently arising. It was serious and attributable to a lack of reasonable parental care. And those, my lord, are set out at paragraph 289 and 290 of the judgment. So turning to the grounds, and my lord, we have amended the skeleton in light of the observation.
Yes, well that's very helpful, thank you very much.
But ground one is perhaps the most important ground for this reason. We say that essentially what the judge undertook was her own evaluation of the medical research that she had been provided with. And that having conducted that analysis, she elevated that. So this is not a case where the medical evidence was elevated and the wider canvas seen against the medical evidence. as in the recent case of R. This is actually a case where the analysis of the medical research was the prism through which all of the other evidence was evaluated, particularly the canvas evidence. It was evaluated above all other evidence. And the result of that was that the very experienced expert, Dr. Hogarth, who came and gave evidence about possibilities, as is required under the letter of instruction that is sent to the experts, who furnished particularly research entitled Atkinson, and was struck by the description of what the adults who were present on the 2nd of February say they saw when R fell back on the sofa and hit his head on the arm of the sofa. That was not given weight or sufficient weight by the learned judge because of the elevation of her own research, of her own analysis of the research.
Did she look at any research that wasn't put before her by the parties?
The research that she looked at was research that two of the experts, Mr. Markham, who was the ophthalmologist, and Dr. Hogarth, who's a neuroradiologist, provided. Two of the other experts, Dr. Elias Jones and Miss Petterini, did not provide any research. During the course of interchange between the learned judge and Dr. Hogarth, Dr. Hogarth referred to other research, particularly the Ibrahim paper, and that was then provided to the learned judge. So she didn't look at additional research.
So it was all in evidence before her?
It was in evidence.
But she says she's entitled to read it herself, and she's not
but
bound by the expert's analysis of that research, is she?
My lord, the problem with that is that the research that has been provided was clearly the research that Dr. Hogarth thought was relevant and that Mr. Markham thought was relevant with the issues in the case. Dr. Hogarth made it very clear in the course of his evidence that this was not comprehensive research. He actually says at one point, I've not given you a plethora of research, otherwise I'd be writing a textbook or words to that effect. There is an inherent danger in somebody not qualified within the field acting essentially as their own expert and evaluating research that is not within their area and is not, there's no way that this could be said to have been the comprehensive research on the issues.
But forgive me, but this is well-travelled ground, isn't it? A judge is entitled, is not bound by experts' opinions. They can form their own view on the material before them, guided to the extent they see fit by the expert evidence. And a judge who does that isn't acting as their own expert, they're acting as a judge.
Well, my lord, the points that she came up with, that she determined were the key points from the research, ignored the possibilities that Dr. Hogarth was putting forward. So in effect, having set out a list of what she determined this research indicated, closed her mind to the oral evidence of the very experienced neuroradiologist, particularly in respect of spinal bleeding. This is an area that Dr. Hogarth was at pains to point out at several points during his oral evidence, and in particular when he was being asked questions by the learned judge, that the data and the research in that area is not well established. There are grey areas. The data in particular, the spinal imaging, is undertaken in the main where there is suspected inflicted injury. It is not undertaken in the same way where there are accidental falls. And he cautioned the learned judge at several points about relying too heavily on
She's not
research.
bound to accept his evidence, is she?
My lord, she's not bound to accept his evidence, but we say that because of her own analysis, which may have been undertaken before Dr. Hogarth gave evidence, there was no way that there was a blank canvas, if I can put it that way, before the court.
How do we know? I just don't see how we know that. I mean, there's material before the judge, placed before her by the experts. She was entitled to read it and form her own view on it as the judge. If she took the view that in the light of that material, which was before her, she didn't accept the expert evidence, I can't see how there's anything wrong with that as a matter of procedure.
My lord, at its nth degree, that scenario would lead to medical research being provided to a trial judge and there not being any need to call any expert.
No, well, the experts were called.
But they were called, but my submission is this. She had undertaken her research and come up with a list which essentially told her that this had to be acceleration, deceleration, that the spine hadn't impacted on the sofa, that the spinal bleeding, which she had been concerned about, would not have been caused by...
Taken to its nth degree, as you put it, that would suggest that even if it was as plain as day that a particular analysis was X from the literature, the judge would be bound to ignore that if an expert said orally that it was wrong. My Lord, there was research that was relied upon, or not relied upon, but certainly put before the court by Dr. Hogarth, was the Atkinson paper. And what the learned judge did is she effectively went through point by point as to why, in effect, the Atkinson paper should be dismissed. And she indicated that little weight could be put upon it, that in effect it wasn't of the quality almost that she could rely upon. That is at odds with the evidence of Dr. Hogarth. But why, forgive me, I'm just struggling here. Why isn't the judge in her judicial capacity perfectly entitled to do that?
Well, she's entitled to look at the research, but she must also listen to the expert evidence.
There's no suggestion she didn't listen and wasn't aware of what the expert was saying.
The issue really is this, that having made up her own decision on the legal research, she then closed her mind to the possibilities that particularly Dr. Hogarth was expressing in his report, because in terms of the experts that appeared before her, Dr. Hogarth was the expert who had done the most amount of research and had looked into the issue of whether the sofa accident could have caused the constellation of injuries. She closed her mind to what his evidence was because she had undertaken her own analysis of that research material.
Well, I think the points you're raising about the expert, about the use of research material, so far as I'm aware, is a novel point that hasn't arisen in any other. I don't recall a judge ever doing this before.
No.
I've never come across a case where a judge has included in the judgment an appendix of her own or his own analysis of research material. So I would like, for my part, just to explore exactly how research material is used in these cases. It may well be consistent with how it's used more broadly. But let's look at how it's used in family proceedings. Now, have you got part 25 with you? You didn't include it in the authorities bundle, and perhaps I should have encouraged you to do so. We have arranged, I've got 3 copies up here of the Red Book. I hope they're the 2023 edition. Can we look, please, and the judge referred to this, but she didn't cite, I think, precise point. I think it's in Practice Direction 25B. Is that right, Ms. Farrington? That is where we see a reference to the expert's duties and references to the research material. Now, can you help us with this, please? I've got it at paragraph 9.1 of Practice Direction 25B under the heading Contents of the Expert's Report. It's page 1988 of the 2023 Red Book. I haven't had a chance to go through the practice direction with a fine-tooth comb. But what it says at paragraph 9.1 point 1F is, in expressing an opinion to the court, sorry, headline, the expert's report must, in expressing an opinion to the court, 1, take into consideration all of the material facts, including any relevant factors arising from ethnic, etc. Identifying the facts, literature, and any other material, including research material, that the expert has relied on in forming an opinion.
Yes.
Now, can you help me, Pete? Is there any other reference? Well, there is, if we go on. 3, indicate whether any proposition report is a hypothesis, in particular a controversial hypothesis, or an opinion deduced in accordance with peer-reviewed and testing technique, research and experience accepted as a consensus in the scientific community. Is there any other reference to the research? Where there is a range of opinion, summarise the range, identify and explain within the range any unknown causes, arising from the facts of the case, including, for example, because there is too little information to form a scientific opinion, or from limited experience or lack of research, peer review, or support in the relevant field of expertise. Now, is that the only reference to research material in practice in Part 25? Please. Do you want to come back to that?
I will come back to that one.
But the use, the research material is cited by experts as part of their duty to express an opinion to the court.
My lord, yes. And in this case, we had 2 experts that didn't cite any research. That was Miss Petterini.
Well, I know, yeah. But, so, the research material is an element in the expert opinion.
It's not, my lord, it's not separate to. That's the issue. It's research that they put before the court, which they are saying has informed their analysis. It's not a freestanding collection of evidence, if I can put it that way, for the judge to make her own evaluation of.
Well, forgive me, I just don't think that follows from this. What this is doing is setting out what the expert's duty is. And what the expert must do, obviously, is identify, in this case, the literature upon which he's relied in forming his opinion. That's what he must do.
Yes.
But it's a very different question as to what is the judge entitled to do with that material.
My lord,
There's quite a lot in the White Book about the approach of the court to experts, and it's quite plain that a judge can't just simply prefer their own theory to that of an expert, that they must set out their reasons for preferring one expert to the other, etc. But what is also quite plain is a judge does not have to accept an expert's evidence, and can prefer, for example, factual evidence to that of an expert. It seems to me a judge can also prefer evidence before them in the form of literature, if it's in evidence before them.
My lord, it's not that she didn't reject the expert evidence. What the learned judge did, and it's this list that she writes, and it's at paragraph 71 of her judgment.
Yes.
Which is 183. Of, in fact, the Annex A. So it's 183, and it's 194 PDF. So, my Lord, just before coming onto that list, Dr. Hogarth was at pains to point out the limitations of research, particularly, I say, in respect to spinal bleeds and imaging in respect to spinal bleeds. The learned judge lists there the larger patterns from her evaluation of the research.
We do need to note that she said exactly, she's borne in mind at 69. I agree with Dr. Hogarth that the literature needs to be read in conjunction with the clinical and radiological evidence experience of the experts. I agree that I need to be careful about over-reliance on the literature, but I trust it is clear from my analysis that I do not disregard it either. These are complex cases and I have set out the strengths and weaknesses of the papers I have read. So she's fully taking on board the points you're making.
Well, my Lord, I say that there is over-reliance on literature. And because if I develop my other arguments, essentially what then happens is that is the prism through which all the other evidence, all the other wider canvas evidence is evaluated. And it leads to other matters, such as a balancing exercise being undertaken, as opposed to findings of fact. Or all of the grounds, essentially, emerge from this as the starting point, because this is key to this, to the learned judge in terms of how she evaluates the case. And what she evaluates in that list are that subdural hemorrhages are statistically significantly associated with abusive head trauma. Rectal hemorrhage correlates strongly with abusive head trauma in children under 3 years old. Falls in infants are common. Most falls result in no injury, and serious injuries from short falls are very rare. Subdural hematoma arising out of short falls are low probability. There is a significant association between spinal injury found on the MRI and abusive head trauma. The two main theories that are set out in literature to explain spinal blood are tracking and direct injury, and none of the literature or the experts set out a well-accepted alternative explanation. So any alternative remains in the realms of the unknown. This is an area which is contentious. When researchers categorise falls, ours would fall with the lower end of the shortfall definition. Symptoms are proximate to shaking injuries, but dating them remains contentious, and reliance on perpetrator statements, as with all witness reports, may not be reliable. I do not have any papers considering symptoms of head trauma more generally.
Right. Which of those propositions do you say is do you challenge those propositions, or the way in which she arrived at them?
My Lord, I challenge them, particularly in this case, because she had evidence that the subdural hemorrhage in this case could possibly have been caused by the fall. So therefore, number one, despite it being statistically significantly associated with abusive head trauma, it's possibly linked to this fall. And that's in the letter of instruction to the experts for a specific reason. This isn't a case where the medical evidence of its own would be sufficient. We know that, case law is quite clear on that, sufficient to make findings. But what has to be looked at is possibilities, and then we look at the wider canvas evidence. The possibilities here, what the learned judge is trying to do, and in my submission you can see it throughout the judgment, is to reach some determination or some definition to find out what happened, to have a definite view about what has caused
Right,
it.
so, forgive me for interrupting you. I just want to be clear about this. I mean, these propositions, the bullet point propositions at the end of this analysis, are broadly supported by the literature.
Yes.
So is it your submission that although they are supported by the literature, they are only part of the evidence before the court? And because of the way in which she treated literature, she elevated it in some way, you're going to develop this, and failed to consider it in the context of all the evidence. I think that is your case, isn't it?
Yes, it is, my lord. Effectively, it's elevated above everything else. Having then alighted on that, having determined that, one senses there's an element of sort of, well, like I can see now how to deal with everything else. She doesn't take into account, particularly the evidence of Dr. Hogarth and Dr. Elias Jones, who conceded that the Atkinson research was important, that in this particular case, not generalities, generalities which research deals with, which is the danger, my lord, in my submission of relying on research. It's statistical. It deals with generalities. It deals with averages. It's this particular case that the judge was charged with examining, not general cases, not what's statistically relevant, but what was in this particular case. And in this particular case, there was a very experienced paediatric neuroradiologist who had come to court and given evidence about how this particular accident, witnessed by 4 adults, could account in particular for the subdural hematoma, in particular for the retinal hemorrhage. He made it very clear that spinal bleeding was a concern, but as he put it, it wasn't something that, he said, you had to be cautious about that.
He said that, but of course there were other experts who took the other view. So the judge had to come to a view on the experts.
But my lord, she didn't come to a view on the experts, because what she did was she cherry-picked from the experts to sort to put into this structure that she had constructed. So unlike other judgments, perhaps, where you get, I heard the evidence of Dr. Hogarth, goes through that, I heard the evidence of Miss Petterini, on this and this, I preferred the evidence of. There was very little of that, and the learned judge made it clear she wasn't going to do that. And what she did in particular with Miss Petterini was she adduced a piece of evidence from Miss Petterini about the possibility of a previous shake before the fall, which had been raised by Dr. Salibo in the medical notes. Now that was judge-led at the end of Miss Petterini's evidence.
Is there anything wrong with that?
There's no criticism of that. It's just that Miss Petterini had not volunteered that. It's not spelt out in her report.
But it was there on the, forgive me for interrupting you, it was there on the papers as a not possibility, wasn't it? Because it had been considered, it had been raised as a possibility by the treating clinician.
Yes, I'm not sure whether Miss Petterini had seen that. The note was pointed out to her by the learned judge. It wasn't something that Miss Petterini had volunteered. It's no criticism of the judge asking Miss Petterini that, but it was a piece of evidence that she later relied upon in forming her view, which was there was some acceleration, deceleration at some point prior to the accident, which then led to the findings which...
We'll come back to that.
Yeah.
But I want, before we leave the treatment of the research in this appendix, I want to ask you something else, if I may. You've accepted that the bullet points in paragraph 71 is a summary of what the research materials said. I think I've taken by themselves.
If you were to take an academic read and to summarise and do a bullet point, that may well be...
In this appendix, I think it's your case, isn't it? The judge considered matters in the research papers that had not been specifically raised by any of the experts.
Yes, there were 2 papers in there that weren't raised, in terms of giving evidence, were not, if I can put it this way, discussed with the experts. They weren't papers that the learned judge put to them, and which she relies upon in forming her analysis. And that's Wells and Adam Baum. Yes,
but is it your case that her reliance on those papers was wrong, or has led her into error?
My lord, it's the attribution of those papers to evidence, particularly of Miss Petterini. So she in turn says that what Miss Petterini has said, well, I can see evidence of that, if you like, within these papers. That wasn't there wasn't any interchange between Ms Petterini and the judge about those papers. And so to rely on that is really what we say is this judge, again, looking in the research, having come up with a list, looking in the research papers to effectively bolster, and I return to this, the structure really, the construct that she'd had about how she saw this case.
Why would there be interchange between the judge and an expert? Presumably they were examined by counsel.
They were examined by counsel, and at the end, in fact with Dr Hogarth, the learned judge was some significant time with Dr Hogarth.
Yes.
And she was...
The fact that the judge doesn't ask questions about a particular paper that's been put before her by the parties doesn't mean she can't rely on it.
Well,
It's been put before her in evidence.
but
it's
how
not
did she
evidence,
get it
my lord, it's not, I wouldn't characterise it as evidence. It's supportive material that the experts have provided the court
Well,
with.
it's either evidence which is before her, or it's not evidence, in which case she obviously can't refer to it. But if it's evidence, she can rely on it. What can be before the judge that isn't evidence? I don't understand the concept.
Well, it's not. It wasn't tested with any of the experts. So if the experts had been asked about it, they may well have said that their view on this particular piece of research.
Well, presumably it was referred to in one of the experts' reports, and annexed to it. So
It wasn't
therefore in evidence.
I mean, the points that the learned judge picks up on are in respect of forces. So, in particular with the Wells paper, the learned judge refers to Miss Petterini's opinion in respect of forces, seeming to be consistent with the Wells paper.
well, let's focus on the Wells paper. Let's take a specific example. So, how did the Wells paper come to be before the judge?
The Wells paper would have been provided by Dr Hogarth.
Well, it would have been. I mean, was it provided by Dr. Hogarth?
That's my understanding of.
Is it cited in his report?
Um,
I'm asking these questions. I can look it up myself, but yes, on page 549.
Unless things are done differently in the family court, what happens is when a witness goes into the witness box, they will be asked to confirm their report and introduce it to evidence. And at that point, everything in their report or referred to in their report will be in evidence.
My lord, it's not uncommon, I have to say, in family cases for experts to refer to research and for the research not to be provided.
Okay, well, let's focus on Wells. At 544, Dr. Hogarth summarises what the Wells paper says. Line 314 to 320. Okay. Now, so that's his summary of it. What do you say about the judge's treatment in the appendix was wrong, for want of a better word? What do you challenge in her treatment of the Wells paper?
The judge reads the Wells paper and then effectively bolsters her view of Miss Petterini, or suggests that Miss Petterini's evidence is bolstered by the Wells paper.
Could you show us exactly, please, sorry to interrupt you,
Yes,
show us exactly what she said?
yes.
So the Wells paper is moves around between them. So is it at 175? Right. And then, that's right, paragraph 23 is her quotation from Dr. Hogarth's report. And she then, in paragraphs 24, 25, 26, makes comments. Are those comments in paragraphs 24 to 26, are they her own reading of the paper, or are they points which arose in oral evidence or in submissions?
My Lord, my understanding, my belief is that they're her own, essentially her own analysis. She very carefully read all of the research.
Okay. Well, let's look in particular at 25, which I think is the point you're making about her use, to use your word, bolster Ms. Petterini's analysis. The writers note that acceleration, deceleration, and force predominate with intentional head injuries, and that unintentional injuries more often involve translational forces, thereby favouring skull fractures and epidural hematomas. It seems to me that Ms. Petterini's analysis on E92 considers this issue. And then she makes other points in 26. What's the point in 25 raised in submissions? Or just in this appendix?
My Lord, I don't believe that was all the submissions were in writing. There was no oral submissions. So
No. Well, I've got your point. For my part, I've got your point about that. But unintentional injuries more often involve translational forces, thereby favouring skull fractures and epidural hematomas. Can we look at which particular analysis of part of Miss Petterini's? Because we've got different page numbers here.
yes, we have.
What is she saying? It bolsters. That's your word. Whatever it is she's saying, that last sentence of 25. What part of Ms. Petterini's document is it supporting or aligned with?
My Lord, I'm just going to bring the document up. We have got different page numbering now, which is yes, it's 575. That is in fact in those two. 575.
Which paragraph?
And it's 4.12, and it's 590 in the PDF.
Four 410.
4.12.
12. I'm sorry. Well, I'm sure it's me. I can't see where in 412 you're referring to. We're looking for the assertion that acceleration, deceleration, force predominate with intentional head injuries, and that unintentional injuries will often involve translational forces, thereby favouring skull fractures and epidural hematomas. Where does that analysis?
I think it's 4.11, sorry, my lord. On the other hand, translation movement forces are generally related to less harm to the brain and the effect of the injury determined by the specific focal contact forces, such as fractures related to a specific impact.
Do we have any definition of translation?
No.
All right.
I think what the judge is doing, isn't she? She is saying that what is in the Wells report appears to be what Dr. Pecorini is
Talking
dealing
about.
with in talking 4.2, the translation.
My lord, that was not, though, explored with Miss Pecorini. So the research, I suppose it comes to the status of the research and the evidence that is adduced. If the learned judge wanted to find from Miss Pecorini whether that was what she was relying on or whether she was using that to support her opinion, she could have asked Miss Pecorini that. She spent a considerable time asking Dr. Hogarth. In our submission, it's another example, really, of I go back to this, using her own framework and then finding bits to fit it. And perhaps the Adams-bound one, which is paragraph B in the skeleton, paragraph 21B, so it's on page 39. Is
Just a moment. Would you mind just giving me this 1 second to let my note catch up? Give me. I'm sorry.
the Adams-bound research,
Yes.
which is at the top of page 39. And if we have a look at the judgment, which is paragraph 119, which is page 138.
I'm so sorry. I can't. Whereabouts in the appendix are you talking about?
This is in the, it's page 138.
Okay, so not in the appendix, in
No,
the
it's
judgment.
in the judgment.
Where does she deal with in the appendix? The Adams bound page. I've lost it. I've seen it, but I can't see it at the moment.
179. Thank you.
Oh yes, it's the top of the page. Right, got it. Sorry. Yes?
So within her judgment, at paragraph 119, so that's at 138, the learned judge notes that the Adams
Right.
bound.
Yes. So this is about
This is about timing.
yeah, well,
So this, my lord, is an important area
yes.
entirely.
Can we do the? Will you forgive me for interrupting you? Can we look at the same? Can we look at the same? Who refers to it in which report?
Adams bound, that will be Dr. Hogarth.
Right. So. Yes. So there it is in his list on, right? And where does he refer to it in his report? It's at 544. Does he refer to it apart from that? In the report?
I don't believe he does.
He doesn't. The key part of his report is at the top of 547. He doesn't refer to it there. No. Okay. Sorry, you wanted to take. Okay, so that's where it reports. Then we see it in the judgment.
Then we see it in the judgment.
119.
119.
Paragraph
138 is the page number.
Well, she tells us there that none of the witnesses were asked
Yes,
about it.
So-
And
My Lord, what we have there is a very clear illustration of the learned judge looking at the research, extrapolating something from that research, which hasn't been discussed or none of the witnesses and none of the experts questioned about it. And on a really key issue, which is the timing of any symptoms of encephalopathy, uses that to say that it's controversial and that injuries described range from mild, which may be missed. Now that's a key aspect of the judge's analysis in how she comes to the findings that she makes, and particularly how she exonerates the grandparents, but leaves in the parents. And she goes on at the end there, I note too that R's presentation evolved. On the sofa he is described as sweating, his eyes deviating and becoming pale. He cried and then went limp and stopped crying. The description there, they are evolving symptoms, but they're not evolving over a period of time. They are symptoms that appear after the event of falling back on the sofa arm as witnessed by the adults. This translates into a sort of latency in
Yes.
the judge's mind, that there are latent symptoms, and this is something that Miss Petterini was asked about, and in her view, it's possible, but it's not usually what. The last time you see a
what
child,
exactly? Forgive me interrupting, but I think this is very important. What did Miss Petterini say about latency? It's not in her report, is it?
It was in her oral evidence, and I believe she was being cross-examined by the local authority, but it's noted.
Is it in the judgment?
138, 138 and it's 114.
Thank you. All right. Okay. So this is the last bullet point in the judge's summary at the end of the appendix, isn't it?
Yes.
Can I understand what your complaint is here? As I understand it, the judge has relied upon a report which was referred to and deduced by your expert, and she has some evidence on that issue from one of the experts called on the other side. And your complaint is that that this issue was not put to certain witnesses.
No, my submission on it is this, that it wasn't relied upon by Dr. Hogarth. It wasn't our expert. They're joint instructions as such, but the expert before the court.
Yes.
It wasn't relied upon by him or put forward as supportive of this contention about the timing of symptoms. The judge's own reading has picked that element of that research out. And the judge has then relied upon that to not give weight to the weight of the other evidence, which was that it would be likely that these symptoms of brain dysfunction would occur very quickly after the event, or quickly after the event, and that the key timing in terms of when an event occurred would be to look at when the child was last well. And of course we had evidence from the grandparents, which this judge, who this judge did find credible, she made actual findings about them, that this child was chatting and babbly and playing with toys. But the learned judge uses this piece of research, if I can put it this way, again, it's to support the foundational structure that she herself has drawn up. And it's not something that was explored at length, apart from, I believe, that one piece of cross-examination with Ms. Petterini on behalf of the local authority. It wasn't suggested to Dr. Elias Jones that would there be symptoms that would be latent that would then come out later on down the line. So this piece of research hasn't been adduced via an expert to support that contention. It's been provided for another reason by Dr. Hogarth, but it's been picked out by the judge because it does go to support her view of the case, which appears to be that there must have been some incident, because that's what my analysis and evaluation of this medical research, tells me. If I analyse it, statistically analyse this medical research, this is what it tells me is more likely to happen.
If in some ways you're criticising in effect the judge's approach, but if she forms the view based upon the evidence, including the expert evidence, that the force that would have been involved in the incident on the sofa could not explain these symptoms, she then looks to see, well, is that conclusion wrong because of the timing of the child's symptoms, and she finds support in the literature and from Ms. Petterini to say, well, not necessarily so. I'm not sure what's wrong with that approach as a judge to reaching your ultimate conclusion as to whether or not, on the balance of probabilities, the injuries resulted from the incident on the sofa.
Well, it ignores Dr. Hogarth's evidence, which is that the force is unknown. That's the first thing.
But she plainly didn't ignore it. She refers to it extensively, but she criticises him in a number of respects and prefers the evidence of Dr. Elias Jones.
But it ignores as well the wider canvas evidence. It ignores the fact that the grandparents, who she considers are credible witnesses, gave evidence, written evidence, was not challenged, and live evidence that the child was well when they arrived. So it's not evaluating. It goes back to this point of not evaluating all of the evidence. It is evaluating the evidence through the prism of what she has decided.
Okay.
The
And that's your
shows.
point. Your point is the judge reached the view on some of the evidence that the forces in the alleged incident involving the sofa,
Witnessed incident of the sofa could not have caused this injury, and fitted her analysis to the rest of the evidence in with that. That's your point, isn't it?
Yes, and ignores other key
And
evidence.
your point
is that the judge had to consider the totality of the evidence
before reaching any conclusions on that.
My lord, yes.
Because although it's unlikely on research evidence that an incident of this, a fall, if that's what it was, of this low-level nature, if that's what it was, could have explained this. It's not impossible, you say, on the research. And consequently, the judge had to consider all of the evidence before reaching any conclusions. Yep.
My lord, yes. to essentially ignore key evidence.
Well,
Or
I think it's difficult to say that the judge ignored it.
No.
The difficulty you face in this case, Ms. Francis, it's difficult to say the judge ignored anything.
Yes.
Because this is one of the most thorough judgments I've ever seen.
Yes.
I think everything's in it.
Absolutely.
You're basically saying there's too much in it. But your point is she started from the wrong position.
Yes, the approach is fundamentally flawed. The approach that I say is ordinarily taken is the judge will evaluate the medical evidence, will not look for what is statistically likely, will keep an open mind to possibilities. I go back to this, that's hence why the letter of instruction asks the experts to do that. That's why case law requires judges to look at the wider canvas and not simply to determine matters by medical evidence. And I say that this goes even further because it's not just on medical evidence, because in fact the medical evidence, when one stood back from it, was that Dr. Hogarth was saying, look, this is a possibility. This vivid description of this child and the aftermath, this is a possibility. That's what the medical evidence background was. What was being elevated, or what was being, that the rest of the evidence was being judged against, was the analysis of the medical research.
Okay. Your real complaint, as I see it, is that you say that she should have accepted Dr. Hogarth's evidence.
Well,
That's your real complaint.
My lord, from the parents' perspective, clearly that's what we dealt with in our closing submissions at length. Not only cross-examination of Dr. Hogarth, but the questions that the learned judge asked him were recorded in our closing submissions. Yes, but what hasn't happened in this case is even a blank canvas, my submission, fair evaluation of the oral evidence. Because I go back to the point that if at the end of the day, the judge can look at the medical research, come up with a bullet point list that reflects the statistical analysis within that research, then there's very little point in having a hearing at the end of the day.
I think that's unfair.
That's a rather dramatic way of putting
But
it.
that's where it takes you to the logic conclusion, because you're, my lord, you're always going to be up against trying to fit in the evidence to the construct.
I mean, I've been very careful, Ms. Farrington, because I've done these cases a lot at first instance, so I must be very careful about war stories of cases that I've heard, I've tried. But the accepted approach is, your judge has to start somewhere, and starting with the medical evidence, expert evidence, is a good place to start. So you can't complain, it seems to me, that she started with the expert evidence.
But, my lord, I don't complain at all about
But
starting medical evidence.
what one does in these circumstances, the judge commonly says, well, the expert evidence leans in this direction, but before I reach a final conclusion, case law requires me to consider that in the context of all the other evidence. That's what Mr. Justice Baker said in whatever case it was.
Very many cases, my lord.
Many cases. And too many cases before my colleague said it. And I have a sense that that's your complaint here, that she didn't do that.
But
She stopped them. She stopped in some way.
that is my argument. It's the elevation. So the elevation of the medical research, then the normal, I say normal, the usual, the conventional approach to how you deal with the judgment, looking at the medical evidence, as I submitted earlier, making perhaps some findings on which medical witness you preferred in terms of evidence, which medical witness you perhaps felt not so confident about accepting their opinion for whatever reason, and then you move on to the wider canvas and you make findings of fact on the oral evidence you've heard, and you determine whether you think anyone has lied, misled the court, been mistaken, and then you tie all of that together and you come to a conclusion. Hence, there are numerous cases where, and the recent case that has been provided last night is an example where the medical evidence in that case was even stronger. The medical evidence was this is likely to be an inflicted injury. But the wider canvas evidence was where the judge in that case didn't pay due regard. Now, in this case, the medical research or the elevation of that had an impact on how the medical evidence was reviewed by the learned judge, and then how the lay evidence was reviewed by the learned judge. Because it reads as if there was a conclusion. I've looked at all this medical research. Statistically, it's so unlikely this fall is going to have caused this. Therefore, I'm then going to evaluate the other evidence with it.
All right. Well, let's look at a specific part of the lay evidence, and that's the witnessed incident and the child's collapse after that. Right?
Yes.
So, unlike many cases, this is a case where there was an incident
Yes.
and followed by a collapse.
Yes.
An important element of the medical evidence before the judge, which all of the experts agreed on, was that, let's get it, to paraphrase, the best clue to when an incident occurred is when the child was last seen to be well. I mean, that's not what they said, but that's what one's heard. That's commonly said, and that's a paraphrase of what was said here. In this case, the child was not seen to be unwell until the incident.
Yes, so the child was seen to be well until the incident, and then after the incident became very quickly unwell.
And how does the judge address that point?
Well, my lord, we've got the judge finding that the grandparents are credible witnesses. She says
Yes.
that within the
Yes.
judgment.
Can I cut you for short? Because I think that's a given. The judge accepted that, well, what exactly did she say? Maybe we should look at it. What exactly was her finding about the child's condition immediately before the collapse?
Well, she accepted that the description they had given.
I mean, she said there was a lot of. She considered what they said and the way the way it had been given by the family members. But what was her ultimate conclusion?
Her ultimate conclusion was that the fall happened and that essentially the descriptions were accurate, but that something else must have happened before.
I know. What was her finding about the child's condition before and after the incident?
138. The story tells me, Lord 138.
Paragraph or page?
Page.
Well, this is.
I'm not sure that was the
Well, that's when she's going through the evidence. That's when she considers it. From a clinical perspective, where does she make the findings about the child's condition at immediately before and after?
My Lord, I have to say it's quite difficult because there are different parts where she deals with this in different ways. So, for instance, in respect of the grandparents, there are paragraphs where she describes what they describe.
Well, I'm looking at the balance sheet analysis, you call it,
Yeah.
and paragraph 275, where she draws the threads together, or seeks to. And she finds there, all experts accept that it's possible that the sofa fall could cause the retinal subdural bleeds. And it's possible that the head injury left no impact. And that there was a witnessed event by 4 witnesses, 2 of whom I found credible. Okay, well that's enough for your purposes. The medical evidence suggests that symptoms take place proximate to the injury. That is the point we just agreed, you and I. He doesn't look visibly unwell in the pictures provided in evidence. Okay? And then against that, makes various points. And the point I'm focusing on is J, I think, at the bottom. No, I. The evidence appears vague and lacking in detail about what happened before.
Yeah.
The grandparents, mustn't name them, didn't hold the child. He was in the background, the focus was not in. So if he were to play minor situations, I'm not confident they would have picked them up.
Well, my Lord, it's not a finding. This is part of the problem with the judgment. My respectful submission is that they're not findings of fact.
Okay, but this isn't a case. Oh, this is a case where there was a dramatic, my word, a significant, a significant collapse.
Yes.
With symptoms of the child becoming unwell after the sofa incident.
Yes.
Where does the judge address, face head on that point, apart from in this little summary she does at 275?
I don't think she does, because if you go down and have a look at 163, page 163, and L. Consensus at the experts' meeting was the injury occurred within 24 hours prior to admission. Although logically symptoms follow injury, the impression I gained was that this was not an exact science and that mild symptoms described in literature may be overlooked. Mild symptoms developed over time.
What does that last sentence mean?
My Lord, I think the learned judge is, to some extent, erroneously considering the symptoms that have developed because they evolved. In the true sense of the word, they evolved, they changed. They didn't evolve over time.
Well,
They evolved
as
over
described by
time.
the parents.
Yes.
Where does the judge confront, which I presume was your point,
Yeah.
that there was a sudden collapse after the sofa incident, which suggested that that was the cause?
She doesn't, because she carries out this balance sheet exercise.
And you referred us to the question about latency.
Yeah.
Just remind us again where that is. That's in Miss Petterini's evidence.
Yeah.
There it is, 114.
Yeah.
I would not expect a latency, but latency has been reported. Is that the only
Yes,
reference to
because Miss
latency?
Petterini was the only expert who was asked about that, and that was on behalf of the local authority.
Okay.
That's my recollection.
At 137, she addresses the timing of the injury.
Again?
There's a paragraph on the timing of the injury.
Paragraph 117.
No, page 137 of it's page 19 of the judgment, but 137.
What paragraph number?
It's paragraph 111, timing of the injury from a
Yes, that's right. That's where we are.
perspective.
We're in all that. That's exactly where we are. I mean, there are 2 points here. That the expert evidence was on the basis of the I presume, imaging, that the injury occurred between within 1 to 3 days of the imaging, presumably, or admission. That's one point. Your point is you can is that the best sign of when the child is when the injury of the child was injured, is when the child was last seen well and when the child collapsed.
Yes. And we've got the evidence of the grandparents, which she accepted. But then what she goes on to do within the balance sheet is to cast doubts upon the evidence of the parents. So there is a whole section within the judgment that deals with the evolution of the description of the noise that the fall made, which takes up a significant amount of judgment.
I know, it's a different point, isn't it? Is there any more in the judgment where she confronts this latency issue? Because on her finding, the child was injured and didn't display symptoms
Yes.
until another incident, a witnessed incident occurred,
Yeah.
following which he collapsed immediately.
Yes.
Where does the judge analyse the likelihood of that?
I don't think she does.
Okay. Now we've covered a lot of ground. We've interrupted you a lot, for which I apologise. Have you finished ground one?
Yes.
You say on ground one.
Yeah.
All right. Where do you want to go from? Anything you want to ask on ground one? Anything you want to ask on ground one? Where do you want to go now?
My lord, I'm just seeing some of the points that I've been asked about and I've made are actually also contained somewhat within ground two. But I suppose to encapsulate, and I'm conscious that and I apologise, the skeleton is long, the judgment was long.
5 page over the limit.
I apologise. The key factor about the evaluation of the Laing evidence is again this unusual approach, which we say is fundamentally flawed, which is taking a balance sheet approach to work out which of the various different options occurred, and without making any findings of fact in terms of credibility, particularly of the parents.
Well, there are 2 points there. First point, the balance point. For my part, I think the balance sheet is just a stylistic thing. I think it's no more than on the one hand, here are the points pointing one way. On the other hand, here are the points pointing the other way. On a balance probabilities, I prefer those points to those. So, what is it about the balance sheet that you particularly that you say
My lord,
undermines her judgment?
It doesn't come, so within the balance sheet, they're not findings of fact as such. A lot of the time they're not.
I see. So
findings
really
of
your
fact.
point is not the fact she's put it in a balance sheet way as you describe it, but the fact she doesn't make findings.
In my submission, I cannot think of another case where I've had a balance sheet approach to a fact finding. They're obviously very common in welfare analysis, where you balance up risks and positives and negatives and positives to perhaps place them to the child in one place and place them to the child in another.
Can I ask you to focus on the second half of this, which is the
Yes.
failure to make findings?
Well, the failure to make findings in my submission is linked to taking a balance sheet approach. It's rather than listening to the evidence and saying, I didn't believe this, or I did believe that, other than the grandparents, which she, as already submitted, she clearly did, there are no actual findings of fact. So, my Lord, you're just left with this, I suppose it's almost like being in the thinking process of somebody's brain before they're making a decision about whether they believe somebody or not, but it doesn't come to a conclusion. There is no finding that the parents lied. The most that comes close to it, she describes them as being evasive. She comments on their use of language being unusual. But there is no passage within the judgment where she finds that they have lied. So there's no need to give a Lucas direction, because there's no finding that anybody has lied. Implicit, she is saying that the parents have lied, because she's saying that they've not told her what happened before the fall. But there's no part of the evidence. There is a very detailed trawl through papers and notes and records to pick up on small differences between what is recorded there and what is recorded elsewhere. But there's ultimately no finding of fact. There's no I didn't believe the mother. And in fact, other points within the balance sheet, she talks about how the mother was described as a loving mother and had been clearly distressed by the proceedings, which was in fact the point that the guardian put forward with the withdrawal application. So it does seem incumbent upon a trial judge to make findings of fact on the lay party's oral evidence.
As part of the balance exercise, her balance exercise, her evaluation, where does she take into account the very positive picture of the parents that emerges from the rest of the evidence?
Well, that's another part of our grounds, my lord, is that even the positives, when she does the risks and the positives evaluation, as per BR, which she had the note of law and she refers to the note of law in the judgment, the learned judge even turns some of the positives into risk factors. So this is ground 3.
Difficulties with the older child.
So we have T,
yes.
who is described as a child, and that is turned into a risk factor. We have the father who is caring for his mother, and that is described as a risk factor. We have reference to the hair strand test, which showed association of the father, I think, with cannabis. And
we have a reference to an old
14 years ago,
criminal
community violence being capable. This is in paragraph 67 of the skeleton. It's paragraph 160 of the judgment. Reference to community violence being capable of being considered a risk factor. That's 14 years ago. There is no weight given to fact of the unchallenged evidence. I say unchallenged. I'll come to one aspect of that in a moment. That these parents immediately reacted to what had happened, took their child to the hospital, sought medical assistance, were discharged, and then because the child vomited overnight, the mother takes the child back, and that is when the scans are undertaken. So there's no weight given to the fact that had somebody been responsible for these injuries, it would seem odd to insist on seeking medical assistance when you've been discharged from the hospital. There is no weight given to that. The parenting assessment, having remind.
I was just going to ask you. So, in these balancing exercises that she carries out, her approach is to look at the 3 possible causes: 268 sofa,
sofa is a fabrication, an incident prior to the sofa incident. Those are the three options, yes? She discounts B, 268B, because she accepts that there was an incident. So really it's therefore A or C. Okay? Where in this analysis does she consider the positive features of the parents? Their otherwise exemplary care of these children. The points you make about the instant seeking of medical attention.
They're not really considered. They're not considered.
Are those factors not considered at all?
No, there are the positives. There are positives that are considered within the balance sheet exercise.
Show us where. Could you show us where they are? I mean, they're not that. Then.
So she says at 275, so 161 little c, this was a witnessed event, albeit not directly by 4 witnesses, 2 of whom I found credible. That's a positive.
Yeah. Well, the 2 points you've identified are the positives in the parents' treatment of the children, generally, and their instant seeking of medical attention.
Yeah.
Where are they? They don't appear in 275.
164, 281, paragraph 281c, we have the parents do not report any other incident or accident.
That's not it.
I don't know whether that's...
So
I'm just going through the positives.
Given the way the judge analysed it, they should appear either at 275 or at 281.
Yes. No, they're in a paragraph. Well, Lord, yeah, the positives are dealt with within the paragraphs, but I don't think they're translated or transferred into the balance sheet.
My lord, they're referred to from 161, paragraph 161 downwards. There are some positive factors.
What paragraph number?
Paragraph 161, that's page 145, downwards.
Paragraph 1, yes. Yes. I now see why I now understand your submission. This ties in with the balancing exercise.
Yes.
What the balancing exercise the judge carried out was this caused by the sofa, or was this caused by another acceleration, deceleration event?
Yeah.
And your point is
It's not making any findings. It's no findings.
and that your point is that the question was whether she was satisfied on a balanced probabilities that the child injuries had been inflicted by
the parents.
an abusive or negligent act
By the
by
parents
the
or the
parents.
grandparents.
And as part of that analysis, she needed to consider the positives.
Yeah.
And the balancing exercise that she carried out did not.
To be
Did
fair,
not
Mum,
include that.
she does consider the positives. It's been pointed out. Well, in fact...
Well, she refers to them early in the judgment, as has been pointed out helpfully, but not in this balancing exercise.
But she also carries out that exercise and then comes to the conclusion that it doesn't matter anyway. So I can just address you on this. It's at 145 and it's paragraph 168. So having looked at the positives and negatives, which is part of the exercise in looking at the wider canvas, the risk factors, the positives, paragraph 168. The presence or absence of any particular factor proves nothing. Children, of course, can be well cared for in a disadvantaged homes or abused in fortunate ones. Each case turns on its own facts. The analysis above, nonetheless, provides a helpful framework by way of background against which I must establish the facts in this case. So above that are the protective factors, which has already been pointed out, start at 161, but they're not in the balance sheet. There are a few sort of positives in the balance sheet, but these aren't transposed to the balance sheet. But then if we read that paragraph at 168, it's not an exercise that this learned judge has placed any value in. So although she's referred herself to the case law on that, because she does, certainly within the note of law, she doesn't consider it to have any forensic value. And my lord, that is at odds as well with the submissions that the Guardian gave within the withdrawal application, where the Guardian referred to the positive parenting assessment of the parents and also reminded the learned judge that at a case management hearing there had been some question mark over whether there should be a parenting assessment because this was a single issue case. And the learned judge said it would be a useful piece of information that would be helpful in determining the facts, the fact finding. Well, that parenting assessment, my lord, is, I don't think it's too high to say, it's an exemplary parenting assessment.
That was before the judge at this hearing.
Yes.
Is it referred to at all?
It is referred to...
In the section, is it referred to in the section?
If 162,
Yeah.
so on the same page,
Yeah, so
155, so within
it's all
the
part of this section 149 to 168,
in the protected factors.
which the judge, you say, didn't take into account in the balance exercise at the end.
Well, I say that on the basis that she said that the factors prove nothing. And then they don't then get transferred into the balancing exercise. Apart from there are, my lord, those few paragraphs or sentences that have a positive element to them. They're not the positives that are identified here, but the parenting assessor is cited at paragraph 162. And the learned judge quotes there from the parenting assessor and says there is clear evidence of nurturing parenting skills. The assessor notes that during the assessment process, warm and loving interactions have been observed between the parents. And I agree with the Guardian that this is an important feature of the broad canvas of evidence that came out of the submissions that the Guardian will put forward on behalf of the Guardian. But it's difficult to see how that did weigh into the balancing exercise that she undertook because it isn't transferred into the balance sheet exercise. But even before we get to that, we have the assertion that the factor proves nothing. Which
but does that indicate potentially an error of approach? Because the submission can't have been that the presence or absence of these factors proved something, but they're surely relevant to whether something is likely or not.
My lady, yes.
And so she's, well, perhaps, in that sentence, the first sentence of paragraph 168, misdirecting herself about the potential relevance of these matters.
Yes, my lady. They are factors that are to be borne in mind when looking at the wider canvas.
Because they might make something more probable or not probable.
Exactly.
Less probable.
Exactly. And that's why even in cases where the medical evidence is strongly in favour of an inflicted injury, there are still cases where the wider canvas allows or persuades the judge not to make a finding. That's an important part.
And since they're relevant, potentially relevant, to whether or not something is more or less probable, it makes it necessary for the judge to make findings rather than leave things hanging in the air. So, for example, at the end of paragraph 158, where she's discussing cannabis use, she says, "I do not overstate this point, but it's inaccurate to ignore it." Well, where does it go?
My lady, there are numerous sentences like that.
And then 160, a similar thing. This was it 160? The reference to the previous
conviction.
And says it could be considered. Well, is it or isn't it?
That there are frequent references to weighing things in the balance. I'm aware that this is hearsay, but I will weigh it in the balance. But it's not clear how is it being weighed in the balance.
Well, she doesn't weigh it in the balance. You say she
doesn't weigh the positives.
She didn't weigh it in at the end. Okay. Well, does that deal with ground 2? I've lost. Or maybe it's not ground 2. Is it ground 2? The balancing exercise?
Yes, it's ground the
2 and 4 overlap, don't they?
and just finally on ground 2, just raise there that much of the evidence that she relies upon from her careful reading of the bundle, the detail that she takes from that bundle, was not put to the parents in cross-examination.
Sorry,
Was not put to...
which paragraph?
This is just 37C. This is our ground 2. Just looking back at the skeleton.
So was it ever put to the parents that there'd been a previous shaking of the child? Was that put to them in cross-examination?
No, I don't recall that being put to them in cross-examination. I don't recall that, but Miss Gibbon will be able to address you.
I believe I did. Yes.
You believe you did. Okay.
But the points that the learned judge draws upon in terms of, for instance, the descriptions of the thud, or the close analysis of the language used, that wasn't explored with the parents. I don't recall the father being asked about the 14-year-old
Conviction.
But, no.
I mean, again, going back to 168.
Oh, no, I think we've covered that. Yes. Yes.
Looking at ground 3, my lord, I think we've covered some of that as well. Characterises positives and protective factors identified in respect of parents' and families' risks, and I think we've dealt with that.
Yeah.
Considering the risk factors makes no findings of fact upon them, gives no weight to the exercise of considering positives and risk. And I think now I should add, and doesn't put any of those positives that are in that paragraph within that balance sheet exercise. So that would be ground 3.
Yeah.
Ground 4, which is page 55 of the bundle, in making findings at the conclusion of the judgment which were not explored with the parents by the advocates or the court whilst they gave evidence. The findings, which are the subject of the appeal, which again are set out within the skeleton, page 56 of the bundle, paragraph 65. And my lord went through these at the start of the hearing. They are essentially findings that cover any numerous scenarios in terms of it could be accidental, could be non-accidental, could be the result of recklessness, negligence. What we say is the key factor here is that the judge had decided that this was acceleration, deceleration, because that's what the medical research told her.
Well, we've covered that already.
Yeah.
But what do you say, what in particular do you say was not put to the parents that it should have been? After all, I would guess it's universally the case that there are not every point that is referred to in a judgment is put to the parents in this sort of case. But what are the, as it were, crucial things you say should have been put and weren't?
Well, in terms of those different scenarios, so whether there was an accident, whether there was negligence or recklessness, they weren't put to the parents. But I'm not sure. The case for the local authority was it was an inflicted injury. That was their case. That was their schedule. I think maybe my submission is better made in this way. Had we had the opportunity to have oral submissions after we had provided written submissions, and the judge could have alerted us to the fact that she was considering making this set of findings, it would have been fairer for those acting for the parents, and those acting on behalf of the parents would have had an opportunity to address the learning judge on those, to make submissions on for instance, C, it is more likely than not to be the sofa incident.
I'm sorry?
It is more likely than not to be the sofa incident, which is C,
right.
which is the third. All of these findings that were clearly at the forefront of her mind. The point of that oral submissions hearing wasn't because parties at that stage were in one mindset. This was a withdrawal application by the local authority.
Yes, but she'd indicated that she wasn't going. She made a decision.
She made a decision she wasn't going to she wasn't going to grant it because it was being made at that stage on a summary basis. So what she wanted was written submissions, and then she would make a decision as to what she was going to do. Does that make?
But wasn't she being encouraged to produce a full judgment?
Well, we wanted a full judgment.
Yes.
That's what we, on behalf of the mother, said. Well, we want a full judgment. Whatever you know, even if there's withdrawal, you will need to deal with the evidence and give a full judgment.
But okay.
But at that stage, the hearing for oral submissions was set up for any questions that the court may have, given that the parties essentially were submitting the same thing for various different reasons. Now that hearing was vacated, so there was no opportunity for those acting on behalf of, or any party for that matter, to make submissions in respect of these findings that were made. I mean, we accept it's open to the judge to make findings, clearly. But whether it's appropriate to do that without giving some kind of notice, particularly in a case where all parties are supporting a withdrawal application.
So she had no submissions contrary to your submissions.
There was a direction for written submissions. Written submissions were provided, but at the same time, there was to be, at that stage when we left court, a hearing for oral submissions after the written submissions had been provided. That was specifically to deal with any questions that the court may have arising out of the written submission.
Okay, well, I'd like you to, I think you've done, by reference to your skeleton, can I just be clear as to what points you say you should have had the opportunity to respond to? Sorry, forgive my inelegant language.
Well, my lord, in terms of much of what the judge says about the parents and their use of language, the paragraphs where she has the details of the use of language and the family, the concerns she has about the strange aspects of the family, we should have had an opportunity to respond to that, because it must have played, I'm not sure, I cannot say, my lord, what weight was placed upon it, but clearly the judge felt it noteworthy and weighed it in the balance.
When a judge is listening to a witness's evidence and is forming an assessment of the language they use, they don't have to put to the witness what their assessment of their language use is.
My lord, maybe I'm talking at cross purposes. Some of the things that she relies upon were not put to the witness. So, for instance, the conviction, other aspects that she draws out from the minutiae. I'm talking about the ability to respond in the oral submissions on behalf of the parents or all of the parties, in terms of some of the aspects of the judgment and how.
But the judge very frequently, should make an assessment of credibility of the witnesses. And in doing that, for my part, I don't think she's obliged to give you an opportunity to respond to every single thought going through her head about that assessment, is she?
But isn't the point that she doesn't really express a view about their credibility? There are two paragraphs towards the end, somewhere around the two, where she says that things don't help the parents' credibility, but she doesn't actually say.
Yeah, that's right. She was.
It's 260.
267.
Yeah, 267 and then 273.
Paragraphs.
Paragraphs, yes, on pages 159 and 160.
Does not enhance their credibility.
Yeah. Well, but what does that mean? Does that mean they're
Well,
not
my lady,
credible?
That's in my submission. That's cited in the skeleton. It's difficult to say what it means. Either you believe the witness or you don't.
Well, you
believe
don't,
the witness.
exactly.
That's the judicial exercise that.
And what is the baseline credibility that isn't enhanced by the thing she refers to?
Well, I've read the judgment as effectively finding that the parents were not credible, because 267 refers to bordering on evasive and the grandparents being more credible, and then 272 I found the grandparents to be credible, and then the parents' evidence I found vague, gave distinct impression they were trying to avoid giving details, in particular of what happened on the day before the fall. Their account shifted in subtle ways. Doesn't help. So I read all that as saying that they were not found to be credible.
Well, my lord, she doesn't say that. She doesn't identify in what way.
Well, in so many words, she does.
But she doesn't say how they've lied. She doesn't say it. And if she had said how they'd lied, then she may well have been in the position of even to give herself a Lucas direction. There's no Lucas direction in this judgment because there's no finding that there is a lie that they have told. To say it's 267.
Forgive me, I thought she did give herself a Lucas direction.
I think it's in the.
It's in the note of it. I mean,
in the
you must have included it in your legal summary of law. Someone talks about A, B, and C, don't they?
Yeah.
The closest we think she gets to it is at I. So 165 of the bundle, paragraph 284I. If the parents were aware of an incident or accident that could have caused these injuries, then they've not been straight through. Well, again, this is in the balance sheet.
There you are.
This may be suggested with a degree of culpability, though I myself that people may lie for a number of different reasons.
Yeah, well, that's.
I suppose that's the Lucas. It's supposed to be a bit more.
I think there's a more substantive
Detail,
one
right.
somewhere.
Well, it'll be in the note of law. It's bound to.
It is in the end. But it's not an actual finding that they've lied.
No.
And to say that they were bordering on evasive at times.
And that's because she's left open the possibility that there may have been an accident.
But she would have to find that they weren't being honest with her because they haven't told her about the accident. Or, there are various possibilities left over. There's if it happened, could have happened unwitnessed.
So I is a sort of hypothetical Lucas direction,
Yes.
but it isn't based on a finding of an actual lie.
No.
So, for which paragraph are you in?
Oh, sorry, 284I on page 165.
There are negative descriptions of the parents' evidence given by the learned judge, but there's no out-and-out finding that she found they were lacking in credibility, or what aspect. She says that they were evasive, they didn't remember details. Whereas she makes a positive finding that the grandparents are credible. So she is able to step outside the balance sheet exercise and to make a positive analysis and come to a conclusion about the grandparents.
Well, as I read 292, she is leaving open the possibility that this was an unwitnessed incident, and that there was a lack of which there would have been a degree of lack of supervision or awareness on the part of the adults. So she's leaving open the possibility that they were not aware of it. It was unwitnessed and they were not aware. That seems to me to be why she may not have found parents lying.
Well, my lord, that paragraph, in fact, that is the paragraph that contains essentially the findings that she's made, and she goes through a whole list of various scenarios.
She's not finding that there was an incident of which, another incident of which they were aware. She's leaving open the possibility they may not have been aware of the other incident.
Yes, but that wouldn't form. How would that form the threshold?
But it means that she's not finding that they're necessarily lying.
Right.
That's how I read it.
Yeah.
My lord, it's simply not clear in my submission because
That's for sure.
because it's done in this balance sheet exercise manner.
Can I help for one thing? Just my lack of knowledge, I think. There doesn't seem to be an order setting out what the findings are.
There is a schedule. I don't know what the order did at the end. I'm afraid
The order is at 106.
It didn't. No.
Normally these days, the order includes findings,
Yes.
a schedule.
The schedule doesn't contain the findings.
No. I'm told, reliably informed by others who remained in the case, that there wasn't an order that.
And the only order that seems to be made was that there be a further case management.
Yes.
So that's what we're appealing.
Of course, the schedule, my lord, if one looks at the schedule that the local authority asked the court to determine, was predicated on an inflicted injury basis.
Yeah. But the judge certainly didn't find that there was an inflicted injury.
She didn't. It was either her finding is her key finding, ultimate finding, or the last is in paragraph 292. Either deliberate, accidental, or negligently arising. This, in my view, is serious attributable lack of reasonable parental care.
But it's a set of findings that covers all options, my lord. It's
Well, she
very-
reaches that. Forgive me, I interrupted you.
the backdrop to that, the foundation for that, is, as we say, because of her evaluation of the medical research, because that's a starting point, and she ends up, well, this, I can't say what's happened, but something's happened.
Well, alternatively, it's because she's approached the question, the whole thing, on the basis, was it caused by the sofa incident or not?
Alex Williams is
And if it wasn't caused, was it caused by the sofa incident, or has everybody lied? Answer no, because she accepts the grandparents, so she dismisses that option. So therefore, her question she asks is, was it the sofa incident or something else involving D? And she answers the question, it was something else. And only addresses the threshold and how that impedes the threshold in the way that my Lord has highlighted in 292.
And it's very difficult to see how those findings, how does one do it? I know a risk assessment has been carried out since then, but
Well, look, yes, well, we've explored this already. The argument is that that's the wrong. The question, was it the sofa incident or something else, is not the right question. The question was did the child sustain injury as a result of a culpable act, to use a neutral phrase, on the part of the parents? And as part of that analysis, you look at the sofa incident and the medical evidence, but you also consider totality of the evidence.
and of course one of the things that she didn't consider, although she does again cite it in terms of case law, is simply unknown cause.
Well, that's yes, okay.
It's not something that it's not given in
Well,
terms of analysis of the medical evidence.
I would be amazed if she doesn't refer. She does refer to the unknown.
No,
Of course
she does refer to it in terms of the,
but not in the balancing exercise.
but not in terms of the balancing exercise, because she approaches it from having undertaken this analysis of the medical research, and that permeates through all the analysis of the other evidence, or at least it's one explanation as to why the analysis is as it is.
Well, she's focusing on the medical. Maybe the reason she's focusing on the research, I'm just thinking aloud now, is because she's decided to address the question, was it the sofa or not?
Yes. And did the spine hit the sofa? That's another question that she finds.
So really your case comes down to, we've ended up with, as so many of these cases do, it comes back to re-T. Look at the evidence and the totality of everything else.
Yes.
All those years ago, for Lady Justice Butler's. Yes.
But so part of the complaint, I mean, I'm just looking at the relevant principles in Annex, whichever annex it is to the judgment, Annex A, on page 185 of the judgment. One of the principles that's cited from this judgment of Mr. Justice MacDonald is at Little Roman 3, no room for finding by the court that something might have happened. The court may decide that it did or that it did not. And part of the point is that she hasn't actually decided what happened because she hasn't said it was a deliberate injury. She said it might have been deliberate, it might have been accidental, and indeed something might have happened that nobody saw.
Yes, my lady.
Yeah, Lord Hoffman. Right. What else do you want to say? You make points about the burden of proof, but
I have. I don't think I need to address your
No.
I'm not sure if there's anything else that I can assist. Is there anything else I can assist with at present?
right. Thank you very much, Miss Farrington and Miss Story Ray.
My lord, the father also appeals, and he supports the arguments that are put forward on the mother's
Is
behalf.
there anything else you want to add?
No.
Thank you. Now, Miss Gibbon. Shall I just ask Counsel for the other father, T's father? Do you want to say anything?
Judge, there's nothing further to add on.
Thank you.
Mr. Appellant. Thank you.
Now, Miss Gibbon, having heard the argument, is there anything else you want to say in opposition to the appeal?
No, my lord.
Thank you. Would you want to ask anything? Do you want to ask anything? Right. Okay, Ms. Arthur.
My lord, on behalf of the Guardian carefully considered the judgment and is satisfied with the analysis that the judge has made and the way in which she reached her conclusions, does not accept the grounds put before the court. During the actual trial itself, the medical research played a large part in the questions that were put to the experts. It wasn't just an addendum onto the report, it was very much part of the evidence, and you can see that in the written submissions. They draw upon, the advocates in the case draw upon the medical research in the written submissions and making it relevant, and also making it incumbent upon the judge to assess it as part of her judgment and in reaching her conclusions as she does.
Yes.
My lord, her role is to draw all the strands together in the case.
Well, can you help us as to where she takes into account in her final analysis the positive factors about the parents at paragraphs 149 of her judgment? She plainly identifies them in that section, but then in the passage that Milady has highlighted in particular, says, puts them to one side, paragraph 168. Where does she bring into her final analysis as to whether or not the local authority had proved its case the positive factors about the family in 149 to 168?
My lord, it's a very detailed judgment, and I would submit that each point that she makes throughout the judgment amounts to an element of her analysis. So by bringing it into the judgment, she's showing that she's taken it into account. The detail in this judgment, to have put every single aspect into the balance sheet would almost be impossible. I think the very fact that it's in the judgment and addressed in the judgment shows that it's part of the judge's balancing exercise.
Thank you.
My Lord, also the part of the grounds was that some of the strands that the judge refers to are not put as findings. She doesn't make findings on each point that she makes. And I would submit that that's not necessary. That the way in which findings are made are by drawing the strands together and then balancing them on probabilities. You don't need to make a finding on each particular point that you make. The act is drawing them together and making a finding. And the Guardian doesn't accept that the judge elevated the medical research. Or used it to fit in to a prejudged point. The Guardians of the view that it was fairly brought into the judgment. It had been explored with the experts. It had been appended to their reports and therefore was part of the evidence before her. And she would have probably been criticised if she'd ignored it. And in fact, some of the evidence, some of the experts that came before the court were criticised for not having considered the medical research thoroughly enough. So it's not really fair when the judge properly includes it in her judgment for her to be criticised for doing so. And the assertion that she's peer reviewing, I think is not fair, my Lord. The experts themselves consider this research in their written reports, the ones that bring it before the court, and the judge carefully explored it with those medical experts who were before her.
Well, the judge had medical experts who were reaching divergent opinions. How is she to decide between those different opinions? Well, she has medical research in front of her, which sets out a body of opinion which she can use to test these specific views of the experts who've given evidence before her. It seems to me it's standard and entirely proper to do that exercise.
Indeed, my Lord, and they were brought to her attention by the experts that are coming to court to advise and assist.
Because it is the basis upon which they have formed their own opinions to a large extent.
So she has a duty to explore them with those experts and within her judgment, and where she considers them relevant to bring them in. My Lord, is there any other aspects that I can assist you with, my Lordship?
Thank you very much, Ms. Seidler.
Thank you.
Ms. Farrington, do you want to respond and reply?
My Lord, no, I don't wish to respond. I've made the points. I don't wish
Thank
to
you.
go over the old ground.
Can I ask what the current position is about the children?
Yes. The current position is this, that tomorrow there is a final welfare hearing. It's listed for 2 days. And my understanding is that the local authority is seeking a 6-month supervision order. And that in fact, in the last 3 weeks, around 3 weeks, there has been unsupervised overnight stay in contact. The children are living with their grandfather. There has been unsupervised stay in contact.
So these proceedings haven't been stayed. There wasn't an application to stay these proceedings.
No. The lower court does know that this hearing is afoot today.
So the hearing before the same judge tomorrow.
Yeah.
Application. So there's a hearing tomorrow. Local authority proposed its supervision order. Is that opposed by anybody?
The Guardian is saying it should be a child in need plan, and the parents are also saying it should be a child in need plan. So it's just the local authority saying supervision order. All other parties saying child in need plan would be sufficient. And it was at the hearing on the either 8th or 7th of March that the judge heard from the local authority that they were proposing, because the parents have been having overnight contact since December of last year, but it's been supervised by either the mother's father or the father's mother. But it was agreed that there could be an element of unsupervised overnight contacts beginning from the week of the 7th of March. And so they've been having effectively 5 nights a week, 2 of which are unsupervised, the Wednesday and Thursday, and then 3 nights are supervised, Friday, Saturday, Sunday. And that's been the position since, I think it's the week of the 8th of March.
Okay. Is there any? So the issue is going to be whether there should be an order or not. Is that
Yes,
right?
and it's going to be dealt with on submissions.
Okay. All right. Written submissions. Or are you going to get a chance to say something?
Can I ask, just to be clear, what are you proposing should be
Yeah, well, that's
if the appeal is successful?
That's my next question.
Yes.
Yeah.
So, my lord, what we would be proposing, and in fact was the outcome in Riyadh, the recent case, would be rather than having a rehearing, that if the appeal succeeds, the local authority would either pursue their withdrawal application, but certainly not. We would like to avoid a rehearing if possible, because obviously the stress and the delay. And currently the plan is either no order or a supervision order, with proportionality of having another rehearing as well. It's clearly another factor.
I'm just going to say something I'm thinking aloud. I don't want the parents to be upset by what I'm saying. I'm thought going through my mind. I suppose the fact that there is this finding might be relevant if there was another child.
My lord, that is precisely why it is so important that this court looks at these findings, that paragraph which contains different assessments of what has happened, because of the effects of future children.
Yes. Do you? So you invite you invite us to do what then? You don't want a rehearing. So what do you invite us to do?
Well, if the appeal is successful, we would ask perhaps that the local authority take a view on whether they wish to proceed with proceedings in terms of having a rehearing, given the circumstances that pertained before the judgment, which was that they were seeking to withdraw.
They would need leave to withdraw, wouldn't they? So what course would you invite us to take? I mean, if we decide, you invite us to dismiss, to allow the appeal and dismiss
the findings
and dismiss the proceedings effectively.
Yeah.
If we take the view that we can't do that, and that there would have to be, the matter would have to be remitted.
Yeah.
The first stage is there would be a case management hearing which you would renew your application. The local authority might renew its application for leave to withdraw.
Yes, I don't know what the
Well,
local
they
authority's
might.
position would be. I know that they.
And you might apply for an order that the proceedings be dismissed in the alternative under
Well, it's
the case
probably,
under the case law.
it's probably going to be the same case law that was before Her Honour previously.
Yeah, okay. But you would invite us if we can't, if we're against you on your principal submission, to remit to another judge.
For a rehearing.
Yes. Or for case management.
Or for case management.
Perhaps Mr. Justice MacDonald
Yes.
is presiding for London in the first instance.
Yes.
He could decide whether or not you should the preliminary application then
Yes.
allocated.
Yes.
What do you invite us to do about the proceedings? Do you invite us to stay the proceedings, or do you want tomorrow to go ahead?
Well, if you just
I don't. Yes. Well, what's your answer to that question? I might go outside for a second.
yeah. Yes, Mr. Sinclair's reminding me that obviously the parents want to have the children home,
Yes, of course.
and whatever the outcome of tomorrow or the next day, the result will be that the children go home. So that's the quandary that they're in. If you stay the proceedings, then the children, there will be no
Well,
penalty on the children.
I don't know whether we're going to be able to give a decision today. I'm going to rise for a moment. We're going to rise for a moment just to consider what course. If we're not in a position to give our decision today, I mean, usually, of course, proceedings are stayed pending appeal, but that's not something you would want us to do in this case.
I think it would cause delay with these children going back, and of course,
Be contrary to their
this incident occurred on the 2nd of February of 2023. So some significant time ago.
Yes. Have you got instructions to what your position would be if we were to allow the appeal?
My Lord, when at the last hearing the parties had considered, the local authority's position was whether or not it was sensible to have the proceedings continue tomorrow, and the parties had hoped that we would be given an indication. The local authority's view is that if that's not possible, it would be sensible to stay on the proceedings. The children already do have a lot of contact with the parents. I don't know what the timescales would be as to how long they would need to be stayed for. If my Lord would be able to give the parties that indication.
Well, let's say it was. I would hope you would get a judgment within 3 or 4 weeks.
In my submission on the local authority's position, it would be sensible to stay.
But if the appeal, what is your position if the appeal is allowed? Have you got instructions? Would you then seek leave to withdraw again? If we allowed the appeal and dismissed the proceedings, that's that. If we allowed the appeal and remitted the proceedings, what do you have instructions of what your position would then be?
I would need to take those. I would need to take those instructions. I would imagine the local authority would look at remitting the application to withdraw.
Okay.
I would agree with Council for Mother that it wouldn't be proportionate to have a rehearing.
Okay, all right. Well, we're just going to rise through this slightly fast.
Sorry, can I just raise one thing? We were wondering whether, Mr. Ray was wondering whether we could stay the proceedings, but whether the local authority would continue with the plan. So in other words...
Would you want to discuss that?
Thank you.
With Miss Gibbons now? Now, yes. Would you do that? It might mean sitting a little after 1 o'clock. We're going to rise for a few minutes. We just take instruction. We're going to have a word outside. Thank you.
Still live
All right.
streaming is on.
Can we leave things here? Thank you very much.
Thank you.
Ms. Farrington, what we've decided to do is that we're going to reserve our judgments. We're not going to give you a decision today, but we're not going to stay the proceedings. So the hearing can go ahead tomorrow.
Yes.
That's our preliminary view. I suppose I should say, do you have any observations about that?
My lord, we were having discussions outside, and the proposal that was being formulated on behalf of the parents was that there would be a stay, that there would be interim supervision orders in order to allow the plan to be carried out, essentially the plan of the local authority.
And did the local authority agree to that proposal?
We were waiting to hear.
No, the local authority
Doesn't agree.
doesn't agree. They need to, there certainly then needs to be a meeting. They're not able to make a very quick decision now, and if we're going to have the hearing tomorrow, then clearly that will give them time to consider that. But at the moment, the view is that the contact arrangements that are taking place at the moment should stay. They wouldn't, pending the outcome of the Court of Appeal judgment.
So you invite us to stay the proceedings, as you said. Is that right?
Yes. Yes.
Okay. Thank you. Stick to our decision. Stick.
Were you inviting us to stay?
So, Ms. Farrington, we're going to. Does the Guardian want to say anything about this?
I don't have anything
Okay.
to add because I haven't been able to take instructions from her. I have
Okay.
tried.
Forgive me, my lord. That is a course of action you can take. Otherwise, but as I've said, the local authority team need to have a meeting to discuss possible views as to whether or not the children do return or whether they keep with the status quo. They would like to have that time, allowing the hearing tomorrow to go ahead. They would be able to do that.
Well, if we don't grant a stay, the hearing tomorrow will go ahead. The proposal is for there to be a supervision order and for the children to go home straight away. Is that right?
Yes, and
That's the unanimous view of the parties. Is that right?
No, my understanding
Oh,
is...
there's an issue about whether there should be a
Yes,
supervision
so
order.
it's whether there should be an order or supervision order. The highest is a supervision order. That the
Yes,
local authority seeks.
that's right.
So my lord, we're having difficulty understanding, given that's the plan of the local authority, why the proceedings can't be stayed, but there can be an agreement to an interim supervision order.
Well, they're not agreeing to it.
Right.
Stick. We're going to stick. It is unusual. We're going to stick to what we said, which is we're going to reserve our judgments, and we're not going to stay the proceedings.
Very well, my lord.
So you will be able to go ahead, make it absolutely clear. Here we'll be able to go ahead tomorrow, and you can have a decision as to ask the judge to make a decision on the final order, whether or not there should be a supervision order.
Yes. And if the appeal succeeds,
Well, we are still debating about what the outcome would then be,
in terms of the final order having been made,
in terms of whether the proceedings are dismissed or remitted.
yes. But so the proceedings will be ended. Yeah.
Should we ask for written submission? Written submission. After having our judgment. Yes. All right. What we'll do is we will hand down our judgments at some point shortly after Easter, after the start of next term, and ask for written submissions then on the brief written submissions on the order following our judgment.
Yes. And the fact that the proceedings will have concluded by then,
Doesn't affect the outcome, because if the appeal is allowed, then they revive.
yeah. Thank you.
Happy? Right. Well, thank you all very much. We're going to reserve judgment, so everybody knows what that means, is that we will we hope very much we'll be able to deliver our judgment within a month. That will come to council initially in draft to provide you with an opportunity to correct any errors, typographical or other minor factual errors. Obviously, it's not an opportunity to re-argue the case. The draft is a confidential document and must not be disclosed beyond those persons to whom it can be disclosed, which will be indicated to you in the ordinary way. You'll know that that's a solemn requirement, and if you were to break it, there would be in contempt of court. And then, in the light of our decision, if we allow the appeal, we will ask for written submissions on the order consequential to our decision. Is that clear?
Yes, it is. Thank you, Madam.
Thank you all very much.